Member for Fairfax.
Thank you, Deputy Speaker, and I'd like to say from the outset that I reject the drivel we heard from the member for Scullin. To come into this chamber and say that the Australian people don't want to see conflict here in this chamber, want to see us to unite, and then to actually oppose a bill and do so ferociously with inflammatory language. Sorry, that just doesn't cut the mustard whatsoever. And as for the implication suggested that this bill represents an offence to New Zealand, let me be very clear. I, like probably every single member of this House, including those opposite, love New Zealand. We don't have a closer friend in the world than New Zealand. And yet the member for Scullin maybe just forgets that what people do want to see in this place is what's in the best interest of Australia, of Australians. What people want to see in this place is their legislators ensuring that the Australian people are kept safe and secure. Absolutely. That is our obligation, and that is an obligation that I believe this bill delivers on. Now, there are many people that come to Australia who love and respect our country, and there are many that don't. It is the aim of this bill, Deputy Speaker, to better identify those that seemingly don't and to remove them before it's too late. While the purpose of this bill, the Migration Amendment Strengthening Character Test Bill of 2019, is not specific to terrorism, it will, however, embolden our efforts to mitigate the risk of terrorist attacks on our soil here in Australia. This bill will do so to answer the call-out from those opposite, Deputy Speaker. I don't blame those in the Labor Party asking such questions on issues of security, because it's not something in their DNA. It's not something they really understand. But, you see, this bill will significantly improve the current legislative framework in relation to discretionary visa refusals and cancellations on character grounds, with the key reform ensuring that non-citizens that have been convicted of a serious designated offence and pose a risk to the Australian community are considered for visa refusal or cancellation. So still the Labor Party are opposed to that, Deputy Speaker. So let me confirm here, those here in this chamber from Labor are opposed to the idea that people who are actually convicted of a serious offence and pose a risk to the Australian community should be considered for visa refusal. Labor Party don't like that idea. Unbelievable. While terrorism is a violent crime that would certainly meet the definition of a designated offence under the provisions of the bill, it is the comprehensive list of violent and related offences committed in either Australia or elsewhere that make the strengthening of current provisions so effective as an early warning mechanism, a mechanism that will not only help ensure that foreign nationals convicted of such crimes are weeded out, but also that future violent non-citizen extremists can be removed from the Australian community, hopefully before they are radicalised to the point where they plan or participate in an attack. Now, this is not to imply, Deputy Speaker, that all or even the greatest risk of violent crimes come from non-citizens residing in Australia, for that is certainly not the case. However, just because Australians must endure homegrown violent offenders, born or naturalised, who prey upon our community, that does not mean that our government or that our society does not mean that our security agencies shouldn't use every means to identify and remove criminal non-citizens that pose a risk and fail to meet community expectations. To me, that is fair and reasonable. The reality is that Australians have very little tolerance for criminal behaviour by foreign nationals who abuse our trust. The right to enter, to stay and to work in Australia is a privilege that should only ever be granted to those of good character. An Australian visa is not a licence to wilfully inflict harm upon Australians. Our generous visa regime should not be an opportunity for any foreign fox to simply enter their henhouse. And those who, by their actions, feel that it is such an opportunity will be identified and will quickly find, thanks to the stronger provisions in this bill, that their visa may be either cancelled or refused at the minister's discretion. In this context, the point should be made that existing processes for the refusal and cancellation of visas are already very robust under Section 501 of the Migration Act, where, under the character provisions, the Australian government can and does regularly cancel the visas of convicted criminal non-citizens, with some 4,000 visas cancelled since 2015. That's a lot of criminal activity removed from our community, Deputy Speaker. Some 4,000 visas cancelled. However, while the existing provisions are effective, the current threshold where an offending non-citizen must be sentenced to a minimum of 12 months in order to trigger the mandatory cancellation or refusal of their visa is not capturing all those found guilty of serious criminality and who may continue to pose a risk to the Australian community. It is important to note that the strengthening of the character test provisions outlined by this bill in no way alters the overall framework within which these provisions operate. There is, for example, no escalation of the aforementioned mandatory cancellation powers that already apply. That is, where a non-citizen would need to be sentenced to a minimum of 12 months or convicted of a sexual offence involving a child in order to trigger mandatory cancellation or refusal of their visa. The amendments to strengthen the character test proposed by this bill significantly provide for discretionary powers only. It was actually a key recommendation, Deputy Speaker, of the 2017 Joint Standing Committee on Migration in their report entitled "No One Teaches You to Become an Australian," that the character test provisions in Section 501 of the Migration Act be strengthened. There is currently a character provision that can be applied to convicted non-citizens that receive lighter sentences and allows additional discretionary consideration based on past and present criminal or general conduct. However, the Joint Standing Committee felt this provision was inadequate to objectively consider the refusal or cancellation of a visa for non-citizen, where their offending did not incur a sentence of 12 months or more, and who, in all probability, would continue to pose an unacceptable safety risk for the Australian community. This bill is a response to the committee's recommendation and provides clear and objective grounds for the minister to consider the refusal or cancellation of a visa for any non-citizen convicted of a designated offence. This amendment will effectively expand the character test beyond a predominantly sentence-based approach by allowing the minister to consider the individual circumstances of the offending and the severity of the conduct in each case. The strengthened character test will set a new objective standard to clearly and consistently determine exactly what constitutes a designated offence, and in doing so will rely on existing criminal law in each state or territory, or even the law of a foreign country, to determine a uniform measure of seriousness for each offence. A designated offence is determined by the bill to be the offences that involve acts of violence against a person, including murder, manslaughter, kidnapping, assault, aggravated burglary and threat of violence, possession or use of a weapon, non-consensual sexual conduct, including sexual assault and sharing an intimate image, breaching a court or tribunal order for the protection of another person, abiding, abetting, counselling or procuring the commission of such a designated offence, including through threats or promises. And where the offence is against Australian law, it must be punishable by imprisonment for a maximum term of not less than 2 years. This bill should serve as a warning to non-citizen sex offenders, violent thugs, wife beaters, child abusers, and anyone who participates in a violent criminal enterprise. Because a commuted sentence or not, a sympathetic magistrate or not, if you are convicted of any of these or equivalent crimes in Australia or overseas, then the minister will look very closely at your visa and adopt a very firm and consistent approach. It should be noted, Deputy Speaker, that where a person's visa is cancelled or refused in Australia, they will be liable for immediate detention under Section 189 of the Migration Act 1958 and be removed from Australia. The Australian community simply will not tolerate violent criminals and sex offenders from other lands who seek to enter and stay in our country. Now, I could go on with examples, Deputy Speaker, but I shall save the House from some pretty awful stories and case studies. But to say that the Liberal National Government is firmly resolute when it comes to protecting the Australian community. Resolute protecting them from violent criminals who enter our country. And provided our laws and actions are compatible with recognised human rights and freedoms, which they are, then our law enforcement and security agencies will find these individuals, no matter where they choose to hide, and once they're convicted, they'll be locked up and kicked out. While the focus of this bill is clearly on addressing the criminal behaviour of non-citizens, it should be remembered that the minister does have the power under the Citizenship Act to denationalise dual citizens for terror-related activity. The dual citizens, who may be seduced by violent extremist ideologies, would do well to consider that fact before they indulge their delusions any further. We should also give thanks, Deputy Speaker, to the fact that Australia, despite some events of recent years, remains such a safe country in which to live, such a safe country in which to raise a family. And we continue to be, in many ways, isolated from the conflict and tragedy that defines and scars so much of this world. However, whether it be our splendid isolation or other reasons, some of that safety can be eroded, and that is the challenge we face. The events of recent years show that the easygoing attitude of Australians, the professionalism of our police and security agencies, and indeed the vast sea that surrounds us, can no longer be relied upon to guarantee our safety as they once did. Australia's migration program must always serve the best interest of Australia, where those interests are labour that's needed to work on farms, service of our communities, the strength of our economy. However, as important of all of these sort of interests might be, they should never override or distort the integrity of our migration program or threaten the security of 25 million Australians. By strengthening the character test, this bill will help to deliver on that obligation. And it's for that reason, Deputy Speaker, that I'm happy to commend this bill to the House.